Welcome to our guide on filing a tort claim against a social worker. This step-by-step guide is designed for pro se parents in Washington state and nationwide, focusing on the Federal Tort Claims Act and state-specific procedures. Welcome to our presentation on filing tort claims against social workers. This guide is tailored for the Federal Tort Claims Act and Washington state procedures. Remember, this is educational and not legal advice. Consult an attorney for specific guidance. This guide is written for pro se parents, those representing themselves without an attorney, who believe a social worker unlawfully or negligently removed their children and wish to pursue a civil tort claim for damages. A tort is a civil wrongdoing that entitles the injured party to compensation. If a government-employed social worker violates your rights during child removal, you may have grounds for a tort claim. This includes constitutional torts under Section 1983 and common law torts like negligence or emotional distress. Federal employees fall under the Federal Tort Claims Act. Determine if your claim falls under federal or Washington state law before filing. This affects filing location, deadlines, and potential damages. Most child welfare social workers in Washington are state employees, so your primary claim will likely be under Washington state law, with a possible parallel 1983 federal civil rights claim. To file a tort claim, identify a legally cognizable harm. Grounds include unlawful seizure without court order or consent, due process violations lacking notice or hearing, negligence in following Department of Children, Youth and Families policy, and malicious prosecution using false information. Each requires demonstrating the social worker's unlawful or negligent actions. Strong evidence is crucial for a successful tort claim. Collect Department of Children, Youth and Families reports, court orders, medical records, and communications with social workers. Gather witness statements and police reports. Document damages like lost wages, therapy costs, and legal fees. Request your Department of Children, Youth and Families file under Revised Code of Washington 13.50 and the Washington Public Records Act. In Washington state, filing an administrative tort claim is mandatory before suing in court, as per Revised Code of Washington 4.92.100. Use the Washington State Tort Claim Form and submit it to the Office of Financial Management. For federal claims, use Standard Form 95. Adhere to deadlines: 3 years for negligence, 2 years for personal injury. Social workers can claim qualified immunity. To overcome it, you must show the right violated was clearly established at the time. Document the specific constitutional violation clearly in your complaint. In Washington, Section 1983 claims borrow the state's 3-year personal injury statute of limitations, which is RCW 4.16.080. The clock starts when you knew or should have known of the violation. Your legal complaint is the formal document that starts your lawsuit. It must clearly tell the court who you are suing, what they did, why it was unlawful, and what you want the court to do. Courts hold pro se filings to a somewhat more lenient standard, but your complaint must still meet basic legal requirements. Understand critical deadlines: 60 days for state response to Washington tort claims, 2 years for federal Standard Form 95 claims, and 3 years for Washington personal injury claims. Serve defendants within 90 days. Avoid common mistakes: skipping administrative claims, missing statutes of limitations, suing the wrong party, and confusing court types. Filing a tort claim against a social worker demands careful planning and execution. Identify your legal theory, gather evidence, and file your administrative claim first. Draft your complaint and seek legal assistance. Utilize resources like the Northwest Justice Project and American Civil Liberties Union of Washington for guidance. Request your DCYF file immediately. Document all damages. Secure witness statements and preserve all written communications. Determine whether your claim is a state tort, a Section 1983 federal civil rights claim, or both. Know the difference between federal and state defendants. Submit the WA State Tort Claim Form to OFM Risk Management. For federal claims, file SF-95 with the appropriate agency. Do not skip this step. After the waiting period expires, file your complaint in the appropriate court. Apply for IFP if you cannot afford filing fees.
This video was generated by artificial intelligence. Welcome to Suing the City, your civil rights guide. This training is designed for pro se litigants whose child was removed without a warrant or probable cause, focusing on holding the city accountable under 42 United States Code Section 1983. We'll cover the First and 14th Amendments, necessary court forms, and proving a custom policy of unconstitutional child removals. The Fourth Amendment protects against unwarranted government seizures, including children. The 14th Amendment ensures your right to family integrity. If a police officer removes your child without a warrant or emergency, these rights are violated, giving you standing to sue. What happened to you is not legal. The First Amendment safeguards your right to petition, ensuring no retaliation for asserting parental rights. It also protects familial association rights. The 14th Amendment's Due Process Clause is crucial. It prevents the government from severing a parent-child relationship without due process. An unwarranted removal violates both these constitutional protections. The Fourth Amendment mandates that police obtain a warrant before removing a child from a parent's home, unless there's immediate, clear danger. Courts evaluate if a reasonable officer would perceive imminent harm. Arbitrary removals not meeting this standard violate civil rights under Section 1983. Courts ask, would a reasonable officer have believed the child faced imminent serious harm? If no, the removal was unconstitutional. 42 United States Code, Section 1983, allows individuals to sue for constitutional rights violations by those acting under state law. You can file a lawsuit against the city, individual police officers, or supervisors who approved the misconduct. This statute is a powerful tool for holding municipal entities and their representatives accountable in federal court. Who can be sued? The city as a municipal entity, Monell claim, the police officer individually, supervisors who ratified the conduct. Under the Monell Doctrine, a city is liable under Section 1983 if a constitutional violation stems from an official policy, custom, or widespread practice. Liability requires showing the city's responsibility, not just employee misconduct. This includes directives, persistent patterns, or deliberate indifference to known issues. For example, if the city knew of the problem and failed to correct it, implying approval. A written policy, like a formal directive authorizing the unconstitutional removal practice, to build a pattern and practice case, gather evidence like records of unwarranted child removals, internal policies, complaint histories, and prior court decisions. Statements from affected parents can serve as witness testimony. Even as a pro se litigant, access these through public records requests or Freedom of Information Act. Other evidence you need to collect: records of other families whose children were removed without warrants in the same jurisdiction, prior court decisions. File your Section 1983 claim in the United States District Court where the incident occurred. Federal question jurisdiction under 28 United States Code, Section 1331, grants automatic subject matter jurisdiction. Importantly, you don't need to exhaust state remedies first. Proceed directly to federal court. Mark Federal Question on your cover sheet. To initiate a federal court case, you must file 4 essential documents: the in forma pauperis application, summons, pro se complaint, and civil cover sheet. These standard administrative office forms are available for free at uscourts.gov/forms. Additionally, check your district's local rules for any specific civil rights complaint templates. In some states, the complaint form is referred to as the non-prisoner complaint. You will need a separate summons for each defendant. The civil cover sheet categorizes your case under nature of suit as 440, civil rights. The Pro Se complaint is your core document, detailing defendants and claims. The summons notifies each defendant, requiring service within 90 days. If you can't afford the filing fee, submit an in forma pauperis motion to potentially waive costs. To draft a successful Section 1983 complaint, include a jurisdiction statement under 28 United States Code Sections 1331, 1343, and list all parties involved. Detail the facts, constitutional claims, and Monell allegations. Clearly request relief, such as damages or injunctions. Use plain language, as clarity is crucial under Federal Rule 8. Because each summons has an address spot for one defendant, you will need to download a separate summons for each defendant. Always include all parties in the defendant's box on the top left side, no matter which summons. Leave the case number blank, the clerk will fill that in. After you file your complaint online or by mail, you will receive a stamped summons. You will need to make copies and serve this summons to all parties. If the social workers are defendants, you can file a service waiver form and have the Attorney General waive service. They are required to approve this waiver. Fill out the waiver, then send it to the AG's office with an envelope and stamp. They will sign their part of the waiver, then they will send it into the court. The city will likely have a different attorney than the social workers, and so will the judge if you are adding the judge. Serving the parties might be the most difficult part because they can and do refuse to accept service, especially judges. You may have to pay to have them served by an outside company. I recommend using ABC Legal. They are nationwide and have successfully served many of the judges I have sued. I never recommend suing a judge because retaliation is so real. Serve the city via the city clerk or attorney under Federal Rules of Civil Procedure Rule 4J2. Serve the officer individually per Federal Rules of Civil Procedure Rule 4E. File proof of service within 90 days. If granted in forma pauperis status, the United States Marshal Service assists pro se filers. Expect the city to argue qualified immunity for officers, claiming no clear rights were violated. Counter with cases like Doe versus Heck. The city may also deny an official policy of removals, present evidence of repeated incidents, and subpoena records during discovery to challenge this defense. You can seek compensatory damages for medical, psychological, lost wages, and emotional distress. Punitive damages are possible against officers for malicious conduct. Injunctive relief can mandate policy changes to prevent future unconstitutional removals. If successful, attorney's fees may be recovered under 42 United States Code, Section 1988, even for self-representation. Understand the statute of limitations for Section 1983 claims. Courts use your state's personal injury deadline, usually 1 to 3 years from the violation date. For minors, some states pause the clock until age 18. Missing this deadline can end your case permanently, so file early. Your action plan begins now. Document everything, request public records, and download necessary court forms. File your complaint before the deadline and seek legal aid if possible. Remember, you have constitutional rights and a legal path to follow. Approach it methodically and with confidence.
This presentation walks through each essential building block of a Section 1983 claim, from pleading standards to who counts as a person under the statute. Understand the law, draft with confidence, and avoid the most common pitfalls that get pro se complaints dismissed. What your complaint must allege to survive a motion to dismiss. Suing cities, counties, and local governments under Monell. Who qualifies as a person, and who is immune from being sued. Official capacity versus personal capacity, a critical distinction. The Supreme Court decisions in Bell Atlantic Corporation v. Twombly and Ashcroft versus Iqbal revolutionized federal pleading standards. Complaints now require a factually detailed, plausible narrative. Mere allegations are insufficient. Specificity is key to surviving a motion to dismiss. Two landmark Supreme Court decisions, Bell Atlantic Corporation v. Twombly, 2007, and Ashcroft versus Iqbal, 2009, fundamentally changed what federal complaints must contain. Gone are the days when a bare allegation was enough. Today, your complaint must tell a factually rich, plausible story. Before 2007, pleading municipal liability under Section 1983 was straightforward. The Ninth Circuit allowed claims to survive dismissal with just a bare allegation of officer conduct aligning with policy. Courts inferred customs from complaints without specific facts, and no heightened standard was required, as confirmed by the Supreme Court in Leatherman versus Tarrant County. The Supreme Court confirmed that no heightened pleading standard applied to the policy or custom requirement for municipal liability. Leatherman versus Tarrant CNTY, 507 U.S. 163, 167-68, 1993. This principle still technically remains, but Twombly changed everything. The modern standard for pleading under Twombly and Iqbal requires complaints to present sufficient factual matter to make claims plausible, not just conceivable. Bare assertions are insufficient. Factual allegations must suggest entitlement to relief. Pro se litigants should focus on specific facts like dates and actions, avoiding mere recitations of legal elements. In Starr versus Baca, the Ninth Circuit established two principles for civil rights pleadings. First, allegations must provide fair notice with sufficient facts, not just legal conclusions. Second, claims must plausibly suggest entitlement to relief, ensuring fairness in subjecting parties to litigation costs. This standard applies to municipal policy claims. Pro se litigants benefit from the liberal construction rule, ensuring their pleadings are read generously. Despite the Twombly/Iqbal framework, courts must afford pro se filings the benefit of the doubt, especially in civil rights cases. While a higher standard applies, pro se litigants aren't held to the same precision as attorneys. Who is a person under 1983? We'll explore which government actors or entities can be sued under this statute, focusing on the definition of persons acting under color of state law. State agencies, as arms of the state, are not persons under Section 1983 and are protected by 11th Amendment immunity. This includes state departments of corrections and the California State Bar. However, private contractors with the state cannot claim this immunity and may be sued if acting under color of state law. The Ninth Circuit now uses a three-factor test to determine if an entity is an arm of the state. Consider the state's intent and function, the level of state control, and the effect on the state treasury. This test helps decide if an entity is immune from lawsuits under Section 1983. State officials can be sued in two ways under Section 1983: official capacity and personal capacity. Official capacity suits target the government entity, allowing only for prospective injunctive relief. Personal capacity suits focus on individual misconduct, enabling claims for monetary damages. Choose wisely, as this decision impacts the relief available and the claim's viability. In official capacity suits, you can seek injunctive relief under the Ex parte Young doctrine for ongoing federal law violations. This includes stopping or changing policies and seeking compliance orders. However, you cannot obtain money damages, as the 11th Amendment protects the state from such claims. For compensation, pursue a personal capacity suit. A personal capacity suit holds officials personally liable for misconduct under state law, bypassing 11th Amendment immunity. Liability requires proving the official's conduct caused the injury, not just their supervisory role. Officials can claim qualified immunity unless they violated a clearly established right. Courts presume damages suits against officials are personal capacity due to automatic bars on official capacity claims. Federal officials are typically not liable under 1983, as it requires state law action. However, they can be liable if conspiring with state officials, creating a state action nexus. For federal misconduct, Pursue a Bivens action for personal capacity claims. Ensure detailed allegations of coordinated actions with state officials to avoid dismissal. When drafting your complaint, clearly state whether each defendant is sued in their official, personal, or both capacities. This clarity is crucial as ambiguity can lead to dismissal or limit your relief options. Courts will determine capacity if not specified, so be deliberate in your pleadings. Before filing your 1983 complaint, ensure you plead specific facts, naming dates, locations, and actions. Identify the right defendant. Avoid suing state agencies. For municipal defendants, describe policies or customs. Anticipate qualified immunity by alleging the right was clearly established, referencing similar cases if possible. For pro se 1983 litigants, remember, facts win cases. Provide specific, plausible allegations as required by Twombly and Iqbal. Know who to sue. State agencies are immune, but individual officials can be sued for damages. Courts read pro se pleadings liberally, so plead facts clearly. Specify defendants' capacities explicitly. Twombly and Iqbal demand specific, plausible factual allegations. Conclusions get thrown out. Your story, in detail, is your strongest tool. State agencies equals immune. Individual officials and personal capacity equals proper defendants for damages. Official capacity equals injunctive relief only ex parte Young. Always state in your complaint whether each defendant is sued in their official capacity, personal capacity, or both. Don't leave it to the court to guess. As a pro se litigant, especially in civil rights cases, courts must read your pleadings liberally and give you the benefit of the doubt. Use this to your advantage, but still plead facts. This guide offers a practical understanding of 42 United States Code 1983 civil rights claims, covering essential elements, municipal liability, Monell claims, tailored for pro se litigants. Section 1983 allows individuals to seek redress for rights violations under state authority. It is not a source of rights, but a means to enforce rights established by the Constitution or federal laws. This legal framework is crucial for addressing civil rights infringements. To succeed in a 1983 claim, plaintiffs must prove two core elements: the defendant acted under color of state law, and the conduct deprived the plaintiff of a constitutional or federal statutory right. These elements ensure accountability for misuse of government authority and protection of established rights. Under 1983, not all government entities qualify as persons. States and territories are excluded, with suits against them barred by the 11th Amendment. However, municipalities like cities and counties are considered persons and can be sued for civil rights violations, as established in Monell v. Department of Social Services. Welcome to Chapter 2, Municipal Liability under the Monell Framework. We'll explore how municipalities can be sued under Section 1983, focusing on the strict conditions established by Monell v. Department of Social Services, 1978. In 1983 cases, municipalities cannot be held liable under respondeat superior. Liability requires proving a constitutional violation caused by a municipal policy or custom, not just an employee's actions. The harm must trace back to a deliberate decision or practice of the government, as established in Connick v. Thompson. Under Monell, municipal liability can be established through three theories: official municipal policy, widespread custom, and failure to train. Each requires proving the municipality itself caused the constitutional violation. Policies must reflect deliberate indifference. Customs must be consistent and widespread, and training deficiencies must directly cause the violation. Municipal policy under Monell includes legislative decisions, final policymaker decisions, ratification, and policies of inaction. Legislative decisions involve laws or rules by city councils. Final policymaker decisions can establish liability, even if isolated. Ratification occurs when a policymaker endorses a subordinate's unconstitutional act. Policies of inaction arise from deliberate failures to act when necessary. A municipality can be liable for a constitutional violation through a well-settled practice, even without a formal policy. This practice must be consistent enough to have the force of law. A single incident or isolated acts are insufficient. Once a custom is established, plaintiffs need not prove policymakers' actual knowledge. Municipal liability for failure to train is challenging to establish. Plaintiffs must prove a rights deprivation occurred due to deliberate indifference. This means city officials consciously disregarded the need for better training. Mere negligence isn't enough. The lack of training must be a deliberate choice, reflecting an obvious risk of rights violations. Municipal liability is distinct from individual officer liability. A city can be held liable for its own actions, even if officers are exonerated. As established in Fairley v. Lumen, a constitutional injury by the city suffices for liability under Section 1983. But an underlying constitutional violation must still be proven. Lockett v. County of Los Angeles supports this requirement. The deliberate indifference standard requires showing a municipality acted with conscious disregard for constitutional rights. This objective test assesses what a reasonable official should have known, not just their actual knowledge. Simple negligence isn't enough. There must be a known risk. This standard applies to all remedies, including damages and injunctions. Bivens' actions allow plaintiffs to sue federal officers directly for constitutional violations, seeking money damages without explicit statutory authorization. These claims focus on individual liability, not vicarious liability. However, Bivens has been significantly narrowed by courts, limiting its application to specific recognized contexts. Section 1983 is not a source of rights, but a vehicle to enforce them, as established in Graham v. Connor. States are not considered persons under Section 1983, making suits against them frivolous, per Will v. Michigan. Municipalities, however, are persons and can be sued if a policy or custom caused the violation, as in Monell. Let's test your understanding of 1983 principles. Consider these questions. What are the two core elements a plaintiff must plead? Can a United States state be sued directly under 1983? Why can't a city be held liable for an employee's actions? Can a single incident establish a municipal custom? What is the fault standard for failure to train claims? What action applies to federal officials? What are the two core elements every 1983 plaintiff must plead? Answer: 1. The defendant acted under color of state law, and 2. The defendant deprived the plaintiff of a right secured by the Constitution or a federal statute. Gibson v. United States, 781 F2D 1334, Ninth Circuit, 1986. Why can't you hold a city liable just because its employee violated your rights? Answer: because 1983 does not allow vicarious liability for municipalities. A city is only responsible for its own illegal acts, meaning a policy, custom, or deliberate decision, not the independent wrongdoing of an employee. Monell 436 U.S. 658, 1978. What standard of fault must the municipality have for a failure to train claim? Answer: the municipality must have acted with deliberate indifference to constitutional rights. A conscious choice, not mere negligence. The training failure must also have actually caused the constitutional violation. City of Canton v. Harris, 489 U.S. 378, 1989. Can a plaintiff sue a U.S. state directly under 1983? Answer: no. States are not persons under 1983, and suits against states are legally frivolous and barred by the 11th Amendment. Will v. Michigan Department of State Police, 491 U.S. 58, 1989. Can a single incident of misconduct establish a municipal custom under 1983? Answer: no. A single incident or isolated acts of misconduct are insufficient to establish a municipal custom. The practice must be of sufficient duration, frequency, and consistency to have the force of law. Gordon versus County of Orange, 6F 4th, 961, 9th Circuit, 2021. What cause of action do you use when a federal, not state, official violates your constitutional rights? Answer: a Bivens action. This is the federal analog to Section 1983, allowing suits directly against individual federal officers for constitutional violations, though courts have significantly limited its scope. Bivens versus 6 unknown named agents, 403 U.S. 388, 1971. Here is an overview of the questions and answers. For Section 1983 claims, plaintiffs must show the defendant acted under state law and violated a constitutional or federal right. States cannot be sued under Section 1983 due to the 11th Amendment. Municipalities are liable only for their own policies, not employee misconduct. A Bivens action is used for federal official violations. Section 1983 enforces existing constitutional and federal rights, not creating new ones. States cannot be sued, but municipalities can, if a policy or custom is proven. Negligence isn't enough. Deliberate indifference must be shown. For federal officials, use a Bivens action, noting its limited scope. Welcome to our discussion on when judicial immunity doesn't apply. We'll explore the legal analysis of Zayas versus Judge McCoy and examine why the dismissal may have been incorrect. This video was created by artificial intelligence, which means it's not wrong. Miriam Zayas filed a federal civil rights complaint against Judge Adrian McCoy, alleging rights violations during a termination trial. The district court dismissed the case with prejudice, citing absolute judicial immunity, leaving no opportunity for amendment. The court invoked the judicial immunity doctrine, referencing Shucker versus Rockwood, to assert judges' immunity from damages for judicial acts within their jurisdiction. Zayas's informa paupera status was revoked due to lack of non-frivolous issues, and her appeal was deemed frivolous, hindering her access to the Ninth Circuit without financial resources. Judicial immunity has limits, and the court's dismissal order may not have applied these limits correctly. This raises questions about whether the court's decision was justified under the established boundaries of judicial immunity. The Supreme Court's two-part test for judicial immunity, established in Stump v. Sparkman, requires both jurisdiction and a judicial act. If either condition fails, immunity does not apply. Zayas's complaint challenges both prongs, questioning the judge's authority and whether the act was judicial. The core question is whether Judge McCoy had jurisdiction. Zayas claims she conducted a termination trial without proper authority. If true, judicial immunity doesn't apply. The Ninth Circuit standard in Shucker mandates that actions must be within court jurisdiction. Jurisdiction cannot be assumed. It must be established. Judicial acts, like rulings and sentencing, are protected by immunity. However, administrative acts, such as organizing dockets or hiring staff, are not. Unauthorized trials may be considered administrative, thus outside immunity. Forrester v. White established that administrative acts by judges lack judicial immunity protection. An ultra vires act occurs when a judge acts beyond their legal authority, completely outside their jurisdiction. In such cases, judicial immunity is lost. Key cases like Bradley v. Fisher and Stump v. Sparkman highlight the distinction between excess of jurisdiction, which is immune, and absence of jurisdiction, which is not. The dismissal's critical flaw lies in the lack of jurisdictional inquiry. The court assumed jurisdiction without verifying Judge McCoy's authority. Additionally, dismissing with prejudice without allowing amendments hindered Zayas from clarifying allegations. Revoking informa pauperis status compounded the harm by blocking access to address arguable legal questions under immunity doctrine. Zayas could have argued that the legal strategies outlined might have altered the case's outcome. These arguments remain viable for future proceedings, potentially impacting the legal landscape. To challenge immunity, argue Judge McCoy lacked jurisdiction over the termination proceeding. Highlight administrative conduct, referencing Forrester versus White. Use the clear absence standard from Bradley versus Fisher and Stump to show no jurisdictional basis. Request leave to amend under Federal Rules of Civil Procedure 15A to address pleading defects. Dismissal with prejudice at the pleading stage without amendment is an abuse of discretion when facts could cure defects. Judicial immunity isn't absolute. Always verify jurisdiction. Detail why the judge lacked authority. Vague claims risk dismissal. Use cases like Stump, Forrester, and Bradley to support your arguments. If informa pauperis is revoked, argue your appeal raises valid legal questions. This is educational content, not legal advice. Consult an attorney for specific guidance.